will proceed to give the floor to Honorable Jerry Ahmed Shaib.
Thank you very much, Honorable Chair. I appreciate the opportunity. My Lord, congratulations and you're welcome. Honorable Chair, if I have your permission, I just want to refer to the Constitution, Article 1461. That states that a justice of the Superior Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. My question is, what would constitute stated misbehavior for you? What are the acts or omissions? About 3 acts or omissions that for you would constitute stated misbehavior, and 3 acts or omissions that you think would not constitute stated misbehavior. Thank you.
Mr. Chairman, if
yes, my Lord, we realize that there is a pending matter on that issue before the courts. So you are sitting in your capacity as a nominee being vetted. You are not sitting here in a capacity as a Supreme Court judge. So I am inclined to humbly overrule the question.
Thank you, Mr. Chairman.
Chairman, with respect, the nominee hasn't made a specific reference to a particular case for, the questioner hasn't made reference to a specific case. I believe that if I understood you right, you are more or less relying on a sub judice principle to rule the question out of order. I humbly submit that to the extent that the nominee is here to express views on the Constitution and public policy matters, you allow him to answer. If we now box ourselves into this situation, then I'm afraid we may not be doing justice to the responsibility imposed on us by the Constitution this morning. He has not referred to a particular matter. And like I argued recently on the floor, the sub judice rule cannot be applied in absolute terms, that there is a matter related somewhere, so Parliament cannot move. He referred to the Constitution and said, what is your view? Give us 3 instances. That is not related to whatever matter you are referring to. In any event, you haven't shared with us the matter that you think, if the question is answered, it will create a problem for same. So I respectfully submit that you permit it.
Honorable members, we all know the matter, even if not expressly stated. He is a Supreme Court nominee before us. Who knows that when the matter, an aspect ends up at the Supreme Court, you may be called upon to preside over it. So, honorable members, it is not proper that we solicit the opinion of a Supreme Court nominee before us on the question being asked. With all due respect, the question is overruled. I will give the floor to the member to ask another question.
Thank you very much, Honorable Chair. Honorable Chair, before asking the question, I just want to make reference to this. It's, with all due deference to you, it has nothing whatsoever for me to do with a pending matter that has to do with the Chief Justice. which you are making reference, if you look at even the paraphrase, it goes on to say that removal of justices of superior courts and chairmen of regional tribunal. So, respectfully, it has nothing whatsoever to do with the stance you are taking now. Because I have asked that, what would constitute? He's going in as a justice of the superior court. And I'm asking, in his view, what would constitute an act or omission that would amount to stated misbehavior?
Honorable member, you know the rules. After the ruling of the chairman or the speaker, we don't argue that. Please ask another question.
Very well. Just for purposes of record. My Lord, respectfully, would you consider superior court judges to have all, when they are supposed to have, as government appointees, they are supposed to file every indication of properties they have. And they do what we call the declaration of assets. Is it something that you would, is it a position you would also consider for judges of the Supreme Court or judges as a whole to also have, as in, file their declaration of assets? And if yes, respectfully, why? And if no, why not? Thank you.
Mr. Chairman.
Honorable nominee, please proceed to answer the question.
Mr. Chairman, as the Honorable said, if that is the law, that all appointees, government appointees, should declare their assets, and judges are government appointees, why not? They have to declare their assets. Thank you.
So is it the case that you have filed your assets declaration?
Yes, Mr. Chairman.
Very well. Honorable Chair, I also want to find out and whether we are considering technological impact on constitutional requirements. So it has to do with Article 68, I think to 9 requires that the Speaker to take presidential oath when acting for the President who is absent and Vice President, but not when the Vice President is acting alone. In an era of instant global communication, does this distinction remain constitutionally necessary? That should the absence from the Republic be redefined? So for instance, when the President is not in town, then we have the Vice President. And when the Vice President is also not in town, we have the Speaker. And we are asking, so in this current technological terms, and what about when all the three of them are out? What would be your position against this technological advancement?
So, Honorable Jerry Shaib, what exactly is your question?
My question is that in this technological advancement stage, when all three are out, the President, Vice President, the Speaker, what would be your position? Do we have the Chief Justice acting?
Yes, Honorable nominee.
Thank you, Mr. Chairman. Even though I'm not very clear with the question, I would say that from my long experience on the bench and from my own wisdom, I scarcely give views and opinions on issues because the view or opinion I'll give carries so much weight. I'm a judge. Who knows whether tomorrow this same issue will come before me? Then I'm expected to go by what I said. Meanwhile, the facts may not be on all fours. So as much as possible, I don't give views and opinions on things, on topical issues like this. Thank you, sir.
Thank you. Any
My
other
Lord,
question?
Just a follow-up. My Lord, is it to say that when there are issues of general knowledge and you're being requested to make a statement on, you will decline doing so just because whenever you make such, it carries weight, so it would mean something else?
No, Mr. Chairman. Currently, there's a situation on hand. Currently, there is somebody acting. So whatever I may say may be this way or that way, which I wouldn't want to do.
But, Honorable Chair, my question was specific, sorry. I made reference to technological advancement.
Honorable member, you are entitled to a follow-up question. And you have
Yes,
asked
I'm
the
just trying to
follow-up
make,
question.
because...
You have asked the follow-up question. Yes, Minority Leader.
Chairman, I want to help to situate the question correctly. My Lord, the gravamen of his question was to the effect that there's clarity on, in the absence of the president, vice president acts. In the absence of the vice president, the speaker acts. And in fact, that has received judicial blessing, where the speaker would even have to take the presidential oath. What he's asking is that in the absence of all these three, so for instance, recently, Mr. President was out of the jurisdiction on an ECOWAS assignment. Madam Vice President, Her Excellency, was on medical leave. Mr. Speaker was also on an official assignment outside of the jurisdiction where there was this constitutional lacuna. What he wants to know is whether in the situation like what I've mentioned, the Chief Justice would have to act or take the presidential oath as acting president. That's the point he wanted to put across.
Mr. Chairman,
whether the Chief Justice or acting Chief Justice or the head of the judiciary.
This is peculiar.
Yeah.
Like you rightly said, if the president is not there, the vice will take the oath. If he's not there, then the speaker, and then it goes down to the Chief Justice. But unfortunately, during that period, there wasn't a substantive Chief Justice, but we have an acting Chief Justice. I don't think the law says that the acting Chief Justice should take an oath. Thank you.
So your answer will be different if there is a substantive Chief Justice.
Yes, ma'am.
And your view is that in that instance, the Chief Justice will have to take the presidential oath as acting president, correct?
Yes.
All right.
Yes, your last question.
Thank you very much, Honorable Chair. My Lord, respectfully, government recently has engaged in a deportation policy of foreigners who have been found to be illegally mining. And my question to you is that, does this violate Article 17 of the Equality Before the Law? And can citizenship status justify different legal treatment for identical criminal conduct?
Mr. Chairman, crime is a crime. Crime doesn't know who commits it. Once you've committed a crime, you must go as to what the law says. So if the law says that a foreigner has committed a crime and after conviction and sentence, they are to be deported, why not? Thank you.
Yes, a follow-up. But in these instances, there's no conviction and sentencing. But the fact that they have been arrested for having conducted themselves in that manner, they are deported. Would you suggest some recommendations?
Thank you, Mr. Chairman. I cannot tell what decision informed that, what reason informed that decision. So I'm not in the position now to say why they were deported. I think it was an executive or decision, so I cannot say why. Thank you.
Thank you very much, my Lord. I wish you all the best.
Thank you.
I will proceed to give the floor to Honorable Bahama Ayariga, the leader of government business.
My Lord, the nominee, Justice Senyo, congratulations on your nomination.
Thank you.
You've been around for a while. I remember recently, and even this morning, the arguments about the proper size of our Supreme Court, how many judges we should have appointed as Supreme Court judges, has been a raging political, legal issue. And even this morning, when you sat there, you were greeted with a statement by the minority leader on that matter. Let me ask, as a member of parliament representing a constituency at the furthest end of the country, that is Boku Central, and an individual seeking justice is entitled to litigate his case up to the Supreme Court by way of right to appeal up to the Supreme Court, depending on where he started the matter. Do you think it is fair that if I'm a citizen of Boku and I start my matter either in Boku or at the High Court in Bolga, I must always travel all the way to Accra to have access to justice at the Supreme Court? Have you thought about the need for a northern bench? Just as you now have a Court of Appeal in Kumasi, and I think you had even started a Court of Appeal in Tamale. I think it went on for a while. And Cape Coast. Have you thought about the need for a northern bench of the Supreme Court so that the people of the North do not always have to travel to Accra when they seek justice in the Supreme Court?
Thank you, Mr. Chairman. We have only one Supreme Court in Ghana, and that court can have several branches, but it's the same Supreme Court, just as the Court of Appeal and the High Courts. So I don't see anything wrong if there's a branch there.
So, to really be fair, maybe we should consider having a branch up north of the same court. Now, you are not opposed to a policy like that, even though you are not in a position to take that decision, but you are not opposed to a policy like that. That's what I gather from your response. As at now, what is the size in terms of the number of the judges in the Supreme Court? Do you recall? I won't hold you to it, but do you recall how many we have now? If you take out the 7 nominees that we have before us.
13, I guess, 13.
You have 13. In 2024, the Chief Justice wrote a letter to the President recommending that the average size of the court should be 20. The letter was made public, I think, by Asase Radio, so I'm sure a lot of people had the opportunity to see the letter. Asase Radio made the letter public. I have the report here, the media report, in which Asase Radio has shared details of the letter requesting the appointment of the 5 judges. And then the letter included a detailed analysis justifying the need for these appointments. So beyond my argument about a northern bench of the court so that people in the north can have access to justice, the letter that the Chief Justice wrote compared Ghana to the US. I don't know if you saw the letter, or at least read the media reportage and discussion of the letter. Because I want to take you through the details. I don't know if you saw the letter or you read the media reports. Just let me know that so that I can know what information to put out when doing the analysis.
Thank you, Mr. Chairman. I haven't cited the letter, but I heard a bit of it on social media.
Well, yeah, the Chief Justice argued, and I don't know if you agree with this argument. Just 3 arguments, and then I would end it there. One, Chief Justice says that there are delays in the administration of justice. Supreme Court judges are overburdened, and, you know, they have to write opinions, they have to hold conferences, and if you have less than 20 judges, it definitely affects the administration of justice at the level of the Supreme Court. Do you agree with that?
Mr. Chairman, I haven't cited the letter you are referring to, and I don't know the reasons given, but from what I heard from you, delays and that the judges are overburdened because of the caseload. The framers of our law, the Constitution, know why they haven't put a limit onto the number of Supreme Court judges. It's not capped. I keep saying that the law is always evolving. Maybe there's a reason. So far as the Constitution doesn't cap the number of judges, I am for it. Thank you.
The second argument that the Chief Justice makes is that we tend to compare ourselves with the U.S. and say the U.S. has a Supreme Court and they have only 9 judges. But the Chief Justice in the letter indicated that in actual fact, in the U.S., they have 50 Supreme Courts in the states, plus the 1 federal Supreme Court. And so you can't compare the Ghanaian situation where we have 1 Supreme Court versus the U.S. that has 50 Supreme Courts at the federal state, at the state level, joining the federal Supreme Court. Do you subscribe to that argument of the Chief Justice?
Yes, Mr. Chairman. See, in the states, every state has its Supreme Court. That is the state Supreme Courts. And then
there are 50 of them.
Yes, and then the Central Federal Court. And even on that, it's only constitutional and federal issues that go to the Federal Supreme Court. And then on top of that, they have the discretion to choose. Unlike here, they have the discretion to say that it's only on 6 cases we sit in the year. So they are not overburdened like we have here. So if the argument of in that letter you said says that due to delays and the caseload, number of judges be increased, fine, I support it. But I guess that the flexibility is there for the evolving nature of the system, which there must be justification for every additional judge. Thank you.
Yeah, the CJ, in making a case for a minimum of 20 judges at the Supreme Court, indicated, for instance, and gave statistics that in 2018, 2019, in the U.S., the federal Supreme Court, the U.S. Supreme Court, the cases filed numbered 6,442. 6,442. But that year, the cases that were argued, out of the 6,442, the cases that were argued were 73 only. And indeed, the cases that were disposed were 69. So you have 6,442, and then you could only, they only disposed of 73, because they, like you said, they have a right to choose what cases to hear and what cases not to hear. But our Supreme Court, disposes, on the average, disposes of about 400 cases in a year, given the pressure on them, and in spite of their numbers, would you say that in spite of the challenges, our judges really do well?
Yes, Mr. Chairman, I will say that they do very well. Our Supreme Court here has 3 main jurisdictions: original, appellate, and supervisory. And even chieftains cases from the National House of Chiefs Appeals go to them. It's loaded, and it's virtually becoming a daily court. So I buy the argument that they are overloaded, and therefore there is the need to increase the numbers.
So in general, you agree with the argument that indeed we need to have more Supreme Court judges so that we can have cases expedited and people's right to have access to the Supreme Court vindicated.
Mr. Chairman, yes, I agree.
The last one, which is generally about the rule of law, You know that investor confidence is also moved by the extent to which a country has the rule of law entrenched. Economic performance is also based on levels of investments in your country. So there is a direct relationship between the rule of law, having access to justice, expedited justice, and economic development. There's a direct relationship, since rule of law is one key indicator that encourages foreign investments into the country. So do you say that if we have more judges and cases are held expeditiously, that the economy of Ghana will do better and all of us will benefit?
Mr. Chairman, that is true, because if within a short period your issues are resolved, why not? You have confidence in the system. But if it takes too much time, then you lose trust in the system. So I will always agree with you that the faster the cases go, the better for the investor community. And then there's trust in the system. And therefore, if the small numbers are going to delay cases, why not? Why don't you increase the numbers so that but that doesn't open the floodgates that you keep rolling out Supreme Court judges. Depending on the exigency and the justification, then the numbers can be increased, sir. Thank you.
But is it not inevitable that we're going to have more numbers, because we are creating districts and each district is demanding a court, and we are creating new regions and each region is demanding, a court, a high court, and we are, graduating many lawyers into the system, and many more people are going to have access to justice, and the lawyers are going to be appealing. Is it not inevitable that the caseload is definitely going to increase? In which case, the right to appeal and therefore the number of cases that will end in the Supreme Court will also increase whether you like it or not.
Thank you, Mr. Chairman. Once people are aware of their rights, they will definitely go to court. And like I said earlier, there must be more courts so that accessibility to justice is very easy. It's good if we have plenty courts and then the cases are spread thin and cases move faster. So I support your idea. The more courts we have, the better for us. Cases go faster. More lawyers are involved. More judges are involved. And the citizens are happy that their cases are heard early and disposed of very early. Cases delayed 10, 20 years, 15 years is not the best. If we have plenty courts and then within few months the cases are disposed of, why not? I am for it, Mr. Chairman. Thank you.
I'm asking this question basically because ultimately it is a burden on the taxpayer. Ultimately, because if we appoint additional judges, the taxpayer has to pay. And, as a nominee, you will have to make a case to the taxpayer why he should pay for your services as part of the considerations that as a committee we will be making. So you do agree that citizens ultimately will benefit if we have an adequately sized number of judges at the Supreme Court?
Mr. Chairman, nothing good in life comes without a cost. Yes, we have to weigh the pros and cons. Yes, I agree that more money will be spent on the judges and the courts, but then the benefit, quick disposal of cases, we weigh all and we go for the more courts to make the citizens and the investor community happy and have confidence and trust in the judiciary. Thank you.
Thank you, Chairman. I have no further questions.
Very well. I will then give the floor to Honorable Hajia Ladi Ayamba.
Thank you, Chairman. Let me first of all say congratulations, well done.
Thank you.
I looked through your CV and I realized that you are a basket of a lot of knowledge and good things in your own industry.
Thank you.
We have observed that in our justice system and justice delivery, many a times, a lot of your work is delayed. A lot of your work is delayed. Someone could be in court for even 10 years. Not even only, not in your place, the superior, but even the lower courts. So there is this perception that justice delayed is justice denied. What is your view on that perception? And what will you suggest to be done to stop or at least to reduce the delayance in justice delivery? Thank you.
Thank you, Mr. Chairman. Some few minutes ago I said we have to look at the tools we use. We have to go high technology now, AI. One of our main constraints is the recording process, writing longhand, and then the processes by themselves. A lot of people who don't know this always say cases delay unnecessarily. Yes, sometimes it does, but then the procedures too, we have to see to it that we shorten the procedures and the time limits. Then secondly, I talk about the tools. If we can go AI, said that recordings are done swiftly, so that by the end of the day, whatever everybody says in court is recorded by the machine, and at the end of the day, it's transcribed, and you can just sign. It makes it faster. And then number two, a lot of adjournments. That one depends on the courts. A lot of lawyers come, I'm sick, I'm that, sending letters and blah, blah. We have to curtail those things as well to make sure that cases go on. And then I said something earlier that there should be time limits. I think the rules of court should set time limits. That no criminal case should go beyond 3 months. No civil case should go beyond a certain period of time. Then we all know we are constrained to finish within that time. These are the things we have to do to be able to quicken cases, to fasten the delivery of justice. And then more courts. If we have more courts, then the workload is lessened. One court wouldn't have plenty cases if there are other courts around. So, Madam, these are some of the things we have to do to be able to deliver justice in good time. In good time. Thank you.
Chairman.
Any further question?
Yes, please.
Please do.
Something of very big interest. If you go to our prisons, most of them are choked. And it's as a matter of judgments, either delayed or wrong judgments or whatsoever. My main worry about those in these prisons are that some of them are not persons whom we should even send to prison, or we should even delay their cases. someone goes to steal a bunch of plantain. An underage goes to steal some rice in a cooker and is eating. All these people, you collect them, you go and dump them, and sometimes even they are not segregated. The hardened, the non-hardened, all of them are together. What will you suggest to ensure that I will call these people, these little pilfering and what have you, they don't find themselves languishing, sometimes even years, sometimes forgotten, either in being called that they are in detention or they are whatsoever.
So, Honorable Hajaladi, what is the question?
My question is, what will you suggest to be done to those people so that we don't get them going into detention and wasting time?
Thank you, Mr. Chairman. Madam, you said we collect them and go and dump them. We don't do that. We try them, and if they are found guilty, they are convicted and sentenced.
Please, I'm not referring to the convicted ones. I'm referring to those that, for instance, you just say, oh, you have to go and come, every day go and come, and the place is choked. When the police cells are full, they remand. You send them to the prisons where maybe they are not even supposed to go. They are the ones I'm referring to, but not the convicted ones.
Thank you, Madam. We, as judges, interpret the law, the laws you make. If you change the laws, we interpret it accordingly. The prosecutors come to ask for remand because they have not finished with investigations. Madam, you can't ask the people to go home. You remand. But like you are saying, of course, it must be reasonable time. So until the laws are changed, there's nothing the judges can do, please. Thank you. So we are waiting for you to change the laws. Then, for example, the penal system, we are looking up to you. If you change it, fine. Thank you.
Yes.
I think I'm done.
Very well. I'll proceed to give the floor to the Deputy Ranking, Honorable Patricia Apiaje.
Right, thank you very much, Mr. Chair. Honorable Nominee, going by your CV, I'd like to ask a question, because if I look at the time that you were born and the time that you entered secondary school, I'd like to find out, at what age did you enter the secondary school?
A little less than 12.
Specifically?
I went to the secondary school in 1970.
Yeah. So we presume that you entered at the age of 11.
11 plus some months, please.
Thank you very much. I found it very interesting because at that time, we had people entering secondary school at the age of 13. So I found it very interesting.
Luckily, my father was a head teacher, so I...
Right, thank you. Honorable Nominee, how many judges do we have at the Supreme Court currently, practicing judges, and how many are women? I'm talking about current one. How many are women?
Currently, we have two, Justice Avril and Justice Mensah Bonso. And then the CJ Justice Tokono, 3.
And how many in total, please?
13.
13. Thank you very much. Honorable Nominee, I'll proceed to bring to your attention that last year, 2024, exactly in June, the Gender Equality Act 1121, was passed. One of the questions I want to put to you at this point in time is that this act mandates gender parity in public appointments. And Article 144 requires merit-based judicial selection. If these provisions conflict, for example, if achieving gender parity requires appointing a less qualified candidate, which takes constitutional precedence and why? Which of the two? I've given you indication of the constitutional and then the legal aspect of it. Thank you.
Mr. Chairman, as much as possible, you should send the best to the Supreme Court, or you should appoint the best wherever. You don't use the gender equality thing to appoint somebody who you think is not qualified, but because of gender. So I will always go for the quality. If it means one person who is qualified, fine, go for that person. Don't say because of gender. If the person is not suitable or qualified for the job, you appoint the person to satisfy gender equality or gender parity. Thank you.
Thank you very much. So, to follow up, I would like to find out, what would you suggest should be the best approach in ensuring the achievement of the gender parity as it exists in the law? Thank you.
Mr. Chairman, if a lady qualifies, or yes, if a lady qualifies for a position, why not? Gender parity does not necessarily mean that you appoint women to satisfy the numbers. No. If the woman is qualified equally as the man, then when you are appointing, you look at that. You don't give the chances to men as against women. But that does not mean that you push ladies who are not qualified for the job to satisfy